So, welcome back to Jurisprudence 2. And just as we introduced the whole of jurisprudence for the academic year last semester, we are not going to repeat the introduction, but just to proceed with the discussion of the topics right away. So, we are going to start the second semester with conceptual analysis of rights and the nature of rights in jurisprudence. And as we move on, you will come to appreciate that when it comes to legal discourse, there are certain terms or certain words or concepts which are taken for granted in the sense that they are used every now and again without people paying attention to its rare legal import, particularly so those concepts or words which are inherently ambiguous in the sense that they are capable of bearing more than one meaning, depending upon the context in which it is being used. And that is why we want to discuss rights and nature of rights in jurisprudence. And we hope to be able to examine the historical and philosophical development of rights. Particularly, we'll be exploring the whole theory as against the interest theory and what the Hohfeld actually brought to the table regarding analysis of rights. And again, we will try and classify different types of rights, particularly rights in rem as against rights in personam, or positive rights as against negative rights. Those who did human rights and some other areas of the law will have encountered somehow some of these things we are talking about. And again, we will try and familiarize ourselves with the contemporary debates and critiques which have been put forward with respect to the nature and scope of rights. So, why should it matter that conceptually we try to clarify rights or the nature of rights? Well, we will note right away that rights form the bedrock or the foundation of modern legal system. Almost everything is now being framed as a right, or we have what they call like the right-based approach. Right-based approach to so many things in both public, private law. Right-based approach is something which is quite all over. It's quite pervasive, and for that matter, we need to understand properly when we say rights. What are rights? What is the true or the proper nature of rights? And again, we notice that when it comes to areas like constitutional law, human rights, and social policy debates, all these leverage or they employ the language of rights in various ways. And that is why we need to also clarify in our mind, when you say right, what are they? So, how may we define right? If you look at old writers like Locke, his famous treatise of government, and also Bentham's, we get the sense that right may typically be regarded as legally or morally recognized entitlement. If someone says that he's entitled to something, and that entitlement can be based upon law, then the person is speaking the language of right. Or the entitlement can be premised on morality, then the person is speaking the language of right in a sense. So therefore, right defines what individuals can demand from others or from the state. And this particular explanation is opposite when we later on come to discuss Hohfeldian analysis of right, particularly so when he talks about the claim right. When he talks about the claim right. So as we have noted, it is important that we study right because right express core values. If you are talking about liberty, liberty is denominated in a currency called rights. If you are talking about equality, we are speaking the language of right. Dignity, we are speaking the language of right. Security, we are speaking the language of right. So therefore, right, as it were, creates a structured relationship between people. Particularly if you are dealing with maybe like property right among private individuals. Somebody is saying that the land over there is for me. I have the right to it. I have the title to it. And I can enjoy exclusive possession. I can exclude all others from it. So, a structured relation between people and also between individuals and institutions. If you are talking about, let's say, constitutional rights against government interference, that the government is not supposed to compulsorily acquire private property unless certain compensations or certain safeguards or assurances have been provided. So, in this way, right is creating a structured relationship between the individual and, let's say, the state, as it were. So we are confronted with the question, are rights fundamentally moral or purely legal constructs? In other words, when we talk about rights, can we say that rights are right because the law has actually chosen to recognize or protect it, in which case it is a legal construct? Or is it the case that rights are something which are grounded in morality? And for that matter, its existence and enjoyment is not so much to do with legal recognition or protection. So we have already met natural law theorists like Aquinas during last semester. We made reference with Summa Theologica, particularly so when he provided his interesting scheme of laws, eternal law, divine law, human law, and natural law. He said that the natural law is the participation of rational beings in the eternal law, and how he talked about the necessity of human law, because not all human beings can work out the requirements of natural law for every situation. So there's a need for some kind of like a predetermination to be made through the instrumentality of human law. And again, we also met legal positivists like Jeremy Bentham and John Austin, who basically made the argument that right exists only because of social consensus or legislative enactment. So if we contrast the natural laws as you saw, they will certainly not see right as emanating from the law, that rights actually exist before the law, even a human law was made, as it were. But then for legal positivists, like Bentham and Austin, they will tell us that when you talk about rights, they are nothing more than what the lawmaker has actually decided to recognize or to create, as it were. Well, if we are to look at the literature even further, we go back to the ancient Greeks. We will see ancient Greeks and the Roman scholars later on. We will see some of their writings, particularly Cicero, who will imply the idea of rightful claims. And for these scholars, they didn't even look at right in terms of what the human law or the man-made law actually recognize. And later on, as we have mentioned in medieval scholasticism or scholastic literature like Aquinas, Justin Martyr, and so on, rights were seen as part of the natural law and emanating from God or from divine reason, as it were. And later on, we met the social contrarians, and somebody like John Locke will make the argument that people have inherent rights to liberty, life, and property. And this, and the emphasis here is that inherent right, meaning that the rights are innate to us by virtue of our humanity, not because the lawmaker has actually chosen to recognize those rights. So that is the John Locke or Lockean foundation of right, that our rights to life, liberty, and property were inherent in us and predated government, predated the establishment of the modern state, as it were. And for that matter, the role of the state is to protect these rights. The role of the state is to protect these rights. And that is why the individual is also supposed to obey the state, because the state will be protecting this right which the individual had before becoming, if you like, a subject of the state. Similarly, we had another contrarian, Jean-Jacques Rousseau, who in the social contract theory will also express the view that, yes, while individuals surrender certain freedom to the general will, fundamental rights remain crucial to human dignity. And you notice that for him, he's talking about individuals, we have our wills, but then when we come together, we have what you call like the combined or the general will, as it were. And if the general will legislate, then it's binding upon everyone. But that notwithstanding, he also concedes that there are certain basic rights which are very essential to human dignity, and those should always be acknowledged or respected. Yeah, we've talked about Jeremy Bentham, the fact that for him, there's nothing like no natural rights, and he and some other scholars will call it even nonsense upon stilts, because for them, if you talk about rights which are valid in law, they arise from law and not inherent morality. So the rights are what they are because the lawmaker has chosen to recognize them. So that is the point that they are making. So these basic ideas expressed across the historical milieu by various intellectual traditions, as we have seen, set up the debate for modern jurisprudence, where the source and legitimacy of rights remain contested. In other words, in our times, when we talk about rights, where do rights come from? How far can the state, the law, go in actually interfering with our rights? Are there any limits? And so on. So let's say a few things about one of these two major divisions of the theories around rights. So will theory, also known as the choice theory of rights. The core idea which is embedded in this will or choice theory of right is that individual autonomy. It emphasizes individual autonomy, and the point is that a right enables a person, that is a right holder, to make choices, to claim or waive, to enforce or release, and so forth. So that is why the starting point for the will theory or the choice theory is the autonomy of the individual. The fact that the individual is able to make choices, is able to decide what it wants to accept and what it doesn't want to accept, or it wants to waive, as it were. Now, the philosophical premise of this will or choice theory, which emphasizes the individual autonomy, can be traced to scholars like Immanuel Kant. Immanuel Kant, in his work, I think somebody signed this up. Yes, who signed this up? Let me see. Is it Emmanuel something? Yes, Emmanuel Entry. You can release your mic. I think he did it accidentally. That's fine. So, Immanuel Kant's idea, what they call the categorical imperative, or which is part of the ontology, provides the basis for the will theory or the choice theory. And Kant stresses that human beings are ends in themselves with free will. And this is very important when we say that a human being is an end in himself as opposed to a means to an end. We have another intellectual tradition called the consequentialists or the utilitarians, who hold the view that it's not so much the end which matters, but the means, as it were. And for that matter, they say that the greatest pleasure for the greatest number of people. So that if so many people are going to benefit, it doesn't matter how it happened. That is all right. Or what we call the consequentialist. So, for example, if we need to engage in certain activities which ordinarily are seen as even appalling or unacceptable, but then if in the end so many people are going to be better off, then it doesn't matter how we got there. Now, for Kant, he is saying that every human being is an end in himself, and you cannot sacrifice anybody in order to achieve a greater good or greater outcome, as it were, as the consequentialist will tell us. So therefore, under the will theory, law is supposed to protect each individual's freedom to choose. So therefore, if in a clinical setting, for example, right, you are a patient, you are in a serious condition, if you freely decide that you do not want any treatment to be done to you, you refuse treatment. And if you are even going to die, so long as that is your choice, the will's theory or the choice theory will recognize that because that is in keeping with your dignity as a person. You have exercised or made a free choice, and that should be respected. It doesn't matter that your free choice is going to end in your death because you are refusing an important treatment. So if you look at the will's or the choice theory, in terms of advantage, one will say that it highlights personal sovereignty. That is to say that a right is meaningful because it grants the holder control. The holder or the right wielder is the one who makes the ultimate decision concerning what should happen and what should not happen. So that one is good. So in that sense, the right holder is seen as a sovereign in a certain respect, isn't it? Because nobody makes the decision. He makes the decision. Again, the will's theory facilitates clear legal doctrines such as capacity to contract, sue, or transfer rights. So when it comes to some other concept like capacity, like to enter a contract, for example, the choice theory or the will's theory will be important. And that is why we were told that every adult is presumed to be compos mentis, and for that matter, has a right to enter into whatever transactions, which is not forbidden by law, or to even acquire property, or to sue and be sued. All these things are based upon the will's or the choice theory of rights. But the other negative side of the will's theory is that it may overlook people who cannot effectively exercise choice. We take children, for example. You remember your law of contract. When it comes to capacity to contract, if you look at cases like Nash and Iman, okay, you will notice that the way the case law developed was in attempt to protect inexperienced children or minors from being exploited by unscrupulous adults. Another disadvantage of the will theory or the choice theory is that it can appear too individualistic, as it tends to ignore broader interests or collective needs. Because if you look at it, it's all about me, or I. That is the personal sovereignty of the individual. But that can also undermine broader interests or collective interests. And that is why, when it comes to the human rights regime, if you look at chapter 5 of the Constitution, there are some instances in which the need for broader interests or public or collective interests, we may have to suspend or we may have to deny the individual certain rights and freedoms, as the case may be. So a typical example is if we look at, let's say, section 21, for example. If you look at section 21, the general fundamental freedoms, I'm talking about article 21 of the 1992 Constitution. And we are told, for example, in article 21, clause 4, nothing in or done under the authority of a law shall be held to be inconsistent with or in contravention of this article, to the extent that the law in question makes provision for imposition of restoration by order of the court that are required in the interest of defense, public safety, or public order on the movement or resident within Ghana of any person. So here, you notice that public interest, public safety are broader interests which are considered as being necessary basis for actually interfering with the individual's personal autonomy. Okay, we move on to interest theory, also known as the benefit theory, in contradistinction to choice or will theory of rights. The core idea, as far as the interest theory or benefit theory of rights is concerned, has to do with the well-being or welfare of the right holder. So, a right exists to protect an important interest that society deems worthy of legal protection. So here, the focus is in the well-being or the welfare of the right holder. And this well-being or the welfare of the right holder is something which is determined by the larger society, for which reason legal protection is being given. Now, the underlying philosophy of the interest theory or the benefit theory of right has to do with utilitarianism, or the utilitarians who include the consequentialists. And they value maximizing overall welfare. So whatever is being done, if it's going to maximize overall welfare or minimize overall pain or disadvantage, then it is worthwhile. So if you take scholars like J.S. Mills and so on, they support such thinking. And similarly, Joseph Raz, one of the relatively contemporary scholars, has put up the argument that a right is justified if it furthers an individual's interests, and the interest is sufficient to impose duties on others. So, for him, as to whether something is worthy to be treated as a right is, first of all, does it safeguard the interests of the individual so much so that it is sufficient to impose duties on others? Now, the advantage of the interest theory is that it explains why even those who cannot personally assert a right, maybe such as minors or those with severe disabilities, still have legally recognized interests. But after all, the focus of this is what society consider as the welfare or the well-being of the individual, for which protection should be given. So here, if you like persons with the rights, a person with the disability rights legislation, you will notice that the number of areas the states, for that matter, the law has given protection because they inure to the welfare or the well-being, or let's say person with severe disabilities, as the case may be. Again, the interest or the benefit theory of right is more consistent with social welfare policies, particularly so as it ensures that law can guarantee or facilitate certain basic goods like health, education. When it comes to matters like health or education, these are matters which impact on the well-being of everyone, so much so that it shouldn't depend upon the autonomy of a person as whether he should be educated or should not be educated, as the case may be. But the disadvantage of the interest theory is that if you take it to its logical conclusion, there is the risk that it may conflict or confuse rights with general utility. And that has a potential of actually pushing personal autonomy aside. If in the name of, oh, it's for good of the collective, the good of the collective, if we are not careful, we end up not having any recognition or protection for the individual's personal autonomy. And then another difficulty is that the interest theory does not provide a clear criteria for making a determination regarding which interests rise to the level of enforceable rights. So that is another challenge. And particularly when it comes to, let's say, economic, social, and cultural rights, for example, we have had challenges with the doctrine of justiciability and non-justiciability. When can we say that certain types of rights are enforceable? Against who? Is it against the state? What about if they are heavy resources laden? Should we still insist that the state should make those rights to be enjoyed? Now we would like to look at another scholar of significant interest, Wesley Newcomb Hohfeld, who did an interesting essay known as the Fundamental Legal Conception. And in this scholarly essay he wrote, he sought to clarify the concept of rights by introducing 4 fundamental legal entitlements and their correlatives. Now, before that, what Hohfeld is trying to do is not completely strange to us as students of philosophy of law. If for nothing at all, last semester, we encountered the scholar called H.L.A. Hart, Professor Hart, and his famous work, The Concept of Law, which all of us read. If you read Hart's Concept of Law, I think within the first 2 chapters, he will be complaining about a particular problem. And that problem has to do with open textured nature of language. That language, and for that matter, law, is open textured. In other words do not have mathematical exactitude in terms of their meaning and their effect. And some words, they actually behave like the chameleon in the sense that they change their meaning or their color according to the complexion of the environment or the context in which it found itself. And if you have all those possibilities, they do not conduce to clear legal thinking and analysis. And that is why he considered it necessary to provide some clarification of certain concepts. So, in Hohfeld's work, as we have noted, he introduced 4 fundamental legal entitlements and their correlatives. So he talked about how to call the claim, privilege, also known as liberty, then power and immunity. Now, with respect to claim, what he called the claim right, and here, Hohfeld is of the view that it imposes a corresponding duty on another. In other words, if I have a claim right, what it means is that another person has got a duty related to the claim right that I have. So there's like a duty bearer. So example, if person A has a claim against person B to repay a loan, B is legally obliged to repay. So that is to say that A's claim right against B means that B has a duty to do something which would enable A to realize or actualize the subject matter of his claim right. And this is important when it comes to even human rights. If you say you have the right to housing, is it a claim right? If it's a claim right, who is the duty bearer? Who is supposed to do certain obligations or duties so as to enable you to realize this claim right you have to housing? In the same vein, Hohfeld talks about what we call privilege or liberty. And with respect to privilege or liberty, he makes the point that there's no corresponding duty on others. It is a freedom to act or not to act without a legal restraint. So that over which you have liberty or what they call privilege, what it means is that no other person is obligated to carry out any duty before you can enjoy that liberty or the privilege. Because in any case, the liberty or the privilege is your freedom to act or not to act without any legal sanction, as it were. So, for example, a person has a liberty to walk in a public space. There's no duty to walk, nor a duty on others to facilitate it. So it just has to do with the fact that the person has the freedom to, let's say, to walk or not to walk, as it were. Are you with me?
Yes, my lord.
Okay. Then Hohfeld also talk about what we call power. And by power, he explained it to mean the ability to change legal relations, either concerning oneself or with others. So that is power. And this has to do with, if you like, capacity, actually. Capacity in a number of legal transactions. And that is why he gave the example that a testator's power to alter inheritance by creating or revoking a will. So if a testator, someone has made a will, and we know that a will does not take effect until a person has actually died. Now that will has created, let's say, an inheritance for you. But the maker of the will, the testator or the testatress, has the power to make changes. If he makes changes, certainly you, the named beneficiary, you may be affected. Or if you even decide to revoke or to cancel the will altogether, certainly you, the future beneficiary, you are going to lose out, because the will which created the benefit for you, be it a device or bequest or legacy, is actually what? It's gone. Then we also have immunity. Immunity, in Hohfeldian sense, prevents others from changing one's legal status. So if another person cannot change your legal status, then what it means is that you enjoy immunity. I'm talking about legal immunity. You enjoy immunity in relation to that person over that which he cannot change your legal status. For example, certain government officials may be immune from particular lawsuits, and thus others cannot impose legal obligations upon them in that context. I'll give you a typical example. If a judge, for example, is writing a judgment, or a judge is presiding over proceedings in court, he cannot be sued for defamation. You cannot sue him for libel or anything, because he has immunity from a legal suit concerning matters that he does in the course of his work as a judge. So maybe if you put in the diagram, this is what Hohfeld is saying. So if you look at like this one, like the right, that is the claim right. And then there's a correlative duty. So there's a duty bearer who is supposed to do something for the wielder of the claim right to actualize or realize his right. Now, that which you have, then you also talk about what we call the privilege, also known as liberty. So if you have liberty, what it means is that over which you have a liberty, nobody can exercise a claim right over that. So nobody has a claim right over that which you have liberty or privilege, as it were. And then he talked about the power. That if you have a power to do something, and we gave the example of like the capacity, then what it means when you exercise that power, it can create liability. For example, you can, for example, enter into a loan agreement. You brought it like a debt, or we gave the example of like the will. You make changes to the will, and then you've created something. So you've exercised the power that you have to change someone's legal status or someone's legal position. Then we also said that over which you enjoy immunity in the sense that all others in relation to that, they have disability. Disability means that in law, they lack the power or the ability to change your legal position or circumstances. Now, Hofer's framework, as we have seen, is significant in the sense that it prevents conceptual confusion. And that is why he said that claim right is not the same as privilege, nor is power the same as what? Immunity. So let's keep that in mind. So if you look at this one, claim right here is not the same as privilege. They are different. And this precision, which Hohfeld endeavors to bring to bear on his work, helped both courts and scholars to articulate precisely which entitlements obligation exists in a given legal situation. And that is why it's not all the time that we say I have a right to something, which it will be proper use of the word right. It may well be that you are saying that you enjoy immunity, which is not the same as a claim right. Is there any question on Hohfeld before we move on? Is there any question on Hohfeld before we move on? Okay, then we'll continue. Yes, Eric.
My Lord, please, my question concerning Husserl's conceptual framework for rights is that can we say that Husserl truly sides with um, the theory of social contract as propounded by J.J. Rousseau and co. to the effect that individuals surrender their right to the state for protection and are therefore supposed to perform some duties for the state in return for the privileges or the rights that the state confers on the individuals.
Okay, Eric, thank you. Not necessarily. What Hohfeld rather seeks to do is to bring some sort of like a better refinement regarding our use of like the various senses of the word right. Now, if we look at all the earlier writers, when they use right, we don't get distinct senses. It's like they are doing one size fits all, kind of. But as you bring your mind close to bear on what Hohfeld is trying to do, he's trying to remind us that it's not all the time that we use the word right that we actually mean right. We will mean some other things, but for lack of conceptual clarity, we use the word right. And that is why he sought to try and to break down into their atomistic unit and say that there are various senses of right. One of those senses is called the claim right, and that there are times that when people say that I have a right to something, if that has been used properly, then they are talking about claim right. Otherwise, they may be talking about some other senses, maybe such as saying that I have a liberty over something, privilege. That is to say that I have something which in law I can do certain things to change other people's legal position in relation to me or that thing. And that may not necessarily be saying that you have like a claim right. That if you have like a claim right, there must be a correlative or a corresponding duty bearer, someone who has an obligation to do or not to do certain things, so as to enable you to enjoy that over which you have the claim right. Yeah, so I think that is the difference. So Hohfeld is trying to be more specific and also more careful regarding the various senses in which we use the word right without even really qualifying it. Yeah, so Eric, so that is what we should note.
Thank you, my Lord. I'm very grateful.
It's 8:51, but we will see if we can. Yeah, Joseph Asante, let's hear you.
Thank you, my Lord. My Lord, regarding the right, I'm making reference to police service. That is in the service instructions that as an officer within the year, you are given 42 days leave, which after the end of the year, by the end of the year, you might have consumed it or finished spending those leave. But at times when you write, they'll tell you there's national issue like incoming sales match and those things. So there's ban on leave. And then sometimes too, there'll be national election and other things. And when these issues are even absent and you write for the leave, like 2 weeks or something, 3 weeks, they'll reduce it. And at times there will be some argument that the leave is it's not your right, but it's a privilege. The leave is not right. It's not your right. The officer that should be, you should at all costs be granted approval to, take a leave, and it's a privilege. So, at what point does a leave become a right, and at what point will it become a privilege, or is a leave privilege or right?
All
If you
right.
can help me.
All right, Joseph, thank you. That's interesting question, but we cannot give you a specific response without looking at all the relevant documentation concerning your situation. Leave in ordinary labor context it will be determined by what the labor act is and also how it's also applied in a particular contract of employment. But then if you are dealing with the security services, we have to look at the relevant regulations and so on before we can understand properly what is happening so that we're able to provide an intelligible response. But for now, we don't have it, so we cannot give any specific response.
Thank you, my Lord.
Okay, so we would like to familiarize ourselves with certain other classifications of rights. So sometimes we talk about rights which are in rem and rights which are in personam. When we say a right is in rem or is an in rem right, what it means is that those rights are enforceable against the entire world. So if you have like a property right, or if the court make a declaration that you have a title to a particular parcel of land, what it means is that that right of yours, which has been pronounced upon by the court of law, is applicable to the whole world until the position of the court has been reversed or set aside. So that is the in rem, is against the entire world. Again, a right which is in personam is a right enforceable only against specific parties. Right enforceable against only specific parties. For example, like contractual rights. And then we all know privity of contract. Originally, how at common law, cases like Twaddle and Atkinson were told that a right could not create a benefit for a stranger or a third party who has not provided a consideration. But of course, as we know, in Ghana, this position has changed. And a right can create a benefit for a third party, even if he has not provided any consideration. We also have positive as against negative rights. So positive rights obligate others, like often the state, to provide goods or services, maybe such as the right to education or the right to healthcare. And the negative rights, on the other hand, require others to refrain from interfering. So when it comes to things like freedom of speech, freedom of religion, freedom of expression, these are a sort of like a negative right in the sense that they do not require the state to do anything, but rather require others refrain from certain actions so as not to undermine the right. And you notice that when it comes to civil and political rights, we have what we call the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights. Now, when it comes to most of the rights which are often classified as civil and political rights, you will notice that most of them are negative rights. Negative rights in the sense that they don't really require the state to provide any goods or services, apart from ensuring that others refrain from doing certain things which will interfere with the enjoyments of those rights. But then when it comes to the economic, social, and cultural rights, you notice that most of them are positive rights because they require the state to do certain things, to spend resources and so on, before they can be enjoyed. Now we have human rights as against legal rights. So human rights, if you look at the Universal Declaration of Human Rights of 1948, we are told that they are universal and inherent by virtue of our common denominator as well as human being. Meaning that every human being, by virtue of being a human being, you have human rights. Then we have legal rights. Legal rights are defined and enforced within a particular legal system. And this may vary by jurisdiction, meaning that human rights, all of us may have a human rights, that is true. But when it comes to legal rights, it's not everyone who may have a legal right because legal rights are defined by particular law and legal system. Then again, we have individual rights as opposed to collective rights. So we have collective rights like which, for example, affect certain communities, like indigenous groups, for example. Remember your human rights law. You've heard of like the Ogoni, okay, the Ogoni people in the Niger Delta, their case, or even you come to Ghana when people were talking about trocosi and so on. We have a group of people who say that there's nothing wrong. This is our culture. This is how certain things are done. So, collective rights that certain communities may hold as a group. It may also apply to like language rights as well. Well, we also have certain contemporary issues affecting rights, particularly expansion of rights discourse. We'll just use a broad brush approach just for you to be aware of some of these things so that we can explore your interest further. We have emergence of environmental rights. People are talking about the fact that the environment also has a right. And there's also a talk about data or data privacy rights. Like these days, for example, we all know this, the Russian gentleman and is it 80 Ghanaian girls and women who are said to have been maybe, I don't know. Who knows? Can somebody give us a little bit of insight into that?
Hey, was in
James,
Accra.
James, what do you know about it?
Well, what I heard was that this gentleman came to Ghana just to come and have a look at the various tourist sites we have. But very fortunate for him, he visited most places and the ladies were very hospitable. So he took advantage by acquainting himself with some of them. And there were some that has been given prophecies by their respective men of God that they will marry white. So most of them met this gentleman and they felt it was prophecy come true. So with the least invitation, they followed this man and the prophecy turned into a bad prophecy and a whole lot of things. But one interesting thing was that the dark shades that the guy was using, you had a system that could record whatever conversation encounter that he ever had with them. So he went and those who are very good in IT created a website and
Are you there? Then we've lost him. Okay, I think he's giving us some reasonable.
he never slept with him. A lot of issues. But the most interesting thing is that he really enjoyed himself and he was so happy to the Ghanaian family that he's even visiting next year. So the ladies should get ready. A whole lot of things. One interesting thing, we are here with them. You call them, they will not mind you. But this white man was calling them and they were just following him. It's up to them. It's up to them.
Yeah, so understand he just said they come with me.
Yes.
And then they just follow. All right, okay. Good. So related to this, for example, we are told there are recordings which have been put on social media and some websites. So the people who are involved, do they have a right, for example, to say that I have not permitted a picture or video of mine to be made for publication in any medium? So that should not be done. So the privacy right, does it extend to data privacy? These are issues which have come up. And again, we also have animal rights activists who even take the view that animals have a right and we cannot subject them to certain cruelty. So all these are coming up, what they call the expansion of the right discourse. Can we create new other rights which were previously not known? And then there's also the issue of cultural relativism as opposed to universalism. In other words, some put up the argument that human rights reflect Western liberal values and may not fit all cultural contexts. In other words, that if we look at the history of development and articulation of human rights in contemporary times, you notice that the West, if I say the West, the Western Europe and then the Americas, the North America, they have played leading role in all this. And for that matter, whatever they are calling human rights is a reflection of their own worldview, including their liberalism. And for that reason, it may not fit all cultural contexts. And we see this thing, China will tell you that what you call democracy is according to your preferred understanding of it. and they too have their own understanding of it. You go to Russia, they tell you something like that. So, human rights, are human rights universal or culturally relative? So these are issues which are coming up. So now, when it comes to something like the so-called LGBT right, for example, there's argument that there are cultures which do not and can never recognize that. However, some cultures actually tolerate that. So, can we universalize such rights, or we should accept the fact that they are culturally relative? So, the issue of cultural relativism as against universalism of rights, they are still ongoing. But some will also take the view that there are certain rights which transcend cultural boundaries, regardless of where you are or where you are coming from. Then again, we also have the issue of balancing of conflicting rights. Rights may not be in harmony all the time, and there's a need to balance. So how do you strike the balance in a society premised upon rule of law and democracy? There's also the issue of judicial activism and rights inflation. So we have critics who sound the note of caution that it is not proper for new demands to be framed as rights. Otherwise, you create a situation in which the courts may overreach policy decision makers. If you keep framing new demands as rights, that may be a backdoor for the courts to becoming policy decision makers, which is not their job. They are not the politicians. And that is the problem with the judicial activism, that should judges, is it right for judges to jump on the bandwagon of rights, to try and frame everything as a right, so as to take issues out of control and determination by politicians and policy makers? Well, proponents also think differently, and they said that it's not so much about judicial activism and the so-called about the rights inflation, but more importantly, the court should be seen as defenders of minority or unpopular causes that the legislatures might ignore. So, in Ghana, for example, we have this issue of LGBT, isn't it? Which has become like an issue of sensitivity in the political class, both the ruling party and then the opposition, because they too were in power not too long ago. And none of them seem to have had the courage to legislate. So, should we say that we should leave it and then the courts will rather come in as and when necessary? Well, there are some other critiques against right. I will let you read the literature, but just before we close, there is something I want us to look at. I want us to attempt to apply Hohfeldian's analytical scheme, okay, to selected rights under Chapter 5 of the Constitution. And as you remember what Hohfeld said, he talked about the claim as an entitlement that correlates with the duty on another party, and then privilege or liberty, that is an entitlement that does not impose a corresponding duty on someone else, or the right holder is free to act or not to act. And then power, the capacity to alter legal relations. And finally, immunity, which protects the right holder from others' powers to change that right holder's legal status. So we want to see how we can apply this Hohfeldian scheme to our constitutional rights. In Chapter 5, we have the various rights, all right, of the Constitution. Chapter 12, guarantee protection of fundamental human rights and freedoms to all people. Article 14, the right to personal liberty. Article 17, the right to equality and freedom from discrimination. Article 18, the right to privacy of home, property, correspondence, and communication. Article 19, the right to a fair trial. Article 20, protection from deprivation of property. Article 21, general fundamental freedoms, including the freedom of movement, assembly, and speech. So this is an overview of the rights. Now let us look at the how we apply Hohfeld scheme to these rights. So if we take the right to personal liberty, for example, in Article 14, okay, let's attempt and use the Hohfeld scheme to analyze it. So from the point of view of a claim right, okay, can we say that every person has a claim against the state and other private individuals not to be arbitrarily detained or deprived of liberty except as permitted by law? So if it's a claim right, then there should be a corroborative duty. Can we say that the police or other state actors have a duty to respect individuals' liberty and refrain from unlawful arrest or detention? And probably if we bring the privilege bit, which is like the liberty, what is it? A person is privileged or is at liberty to move freely within Ghana, absent specific legal constraints. And this liberty or privilege, in Hohfeldian sense, imposes no direct duty on others to facilitate movement beyond not interfering illegally. Now, what about power bit? So power. A court or a judge has the power to authorize lawful detention or grant bail. And so, and for that matter, the judge will have altered the individual's legal status from detained to free on bail, as it were. What about immunity? Still dealing with the Article 14, the right to personal liberty. We are trying to see how we can use Hohfeldian analysis to analyze some of these rights. So still on the right to personal liberty and Article 14, we have immunity. An individual may also enjoy an immunity from indefinite detention, meaning state authorities lack the power to keep that person in custody beyond constitutional or statutory limits. So you see how the Hohfeldian concept has been used to analyze some of these rights. I will take another one, equality and freedom from discrimination. Article 17. So why is the claim right? Citizens have a claim against both government agencies and private entities not to be discriminated based on gender, race, religion, and so on. Correlative duty. All public officers and private persons have a duty to treat individuals fairly without discriminatory practices. And then let's look at the privilege aspect. Each individual has a privilege to seek or apply for opportunities, maybe jobs, admissions, and so on an equal footing, assuming no legal constraint. And this freedom does not require others to create opportunities, but obliges them not to discriminate. So let's look at the power aspect. A victim of discrimination can exercise a power to file a suit or petition in a court, thus initiating legal proceedings that can alter the defendant's legal obligations. Maybe example, ordering compensation or an injunction against discriminatory behavior. And finally, let's look at immunity in relation to Article 17. Once recognized as fundamental right, certain aspects of non-discrimination may be immune from legislative curtailment, meaning the legislature cannot pass laws that directly infringe core equality principles. So these are not perfect translations, but at least they give you a sense of how you may use the Hohfeldian analysis to actually sharpen our appreciation of some of these areas of the law. So we will draw the curtain down here unless someone has a question.